Hi, everybody. My name is Blair McClanahan. I am an attorney from the law office of Cheryl David. Our firm is located in Greensboro, North Carolina, and we've been providing educational workshops just like this in our community for over 30 years. Now, not everybody knows this, but one of the reasons I'm so passionate about educating our community about their estate planning options is because my mother is Cheryl David, the owner of this law firm. So I've really grown up ingrained with this in me. I've always seen her out and about in the community, weekly dinners at the K&W, and saw her interactions with the clients. And overall, it was a positive experience, not one that you're used to seeing a lawyer get with their clients. So it was a no-brainer for me after college to go to law school and join her in the firm. So as I'm sure you're aware, not all families are created equal when it comes to planning ahead or even talking through planning decisions. So today, I would like to give everyone some really good information so that everyone can be on a level playing field. So I'm really fortunate to have a whole team behind me that really cares deeply about helping families keep relationships intact and taking care of each family member in a way that's best for everybody. No one plan is going to be exactly alike. And we do understand that not everyone can attend a workshop in person. So to ensure that everyone has an opportunity to learn the basics and understand what options we have, we've created this webinar. So I'd like to formally welcome you to this estate planning webinar. It should last around an hour, hopefully a little less, and we're going to really dive deep into asset protection and nursing home protection. So although we love meeting people in person, and that's always our favorite way to interact with our clients, we do hope that as you watch this, you'll feel like you're in the room with us. Our goal is to create an educational experience where our clients and future clients can learn how to protect their families from the comfort of their own home. But that'll only work if we can make everyone feel like they've gotten to know us and our commitment to helping families like yours in North Carolina. So please give us your feedback about this webinar. We're going to continue to fine tune this until we have it perfect. So to help you get the most out of this webinar, I would like to point out a couple features. So somewhere on your screen, I think towards the bottom, there should be a button called chat or a bar where you can answer questions if everyone can go to that section and click on it. This should open up a chat window that allows you to communicate with us. We have an attorney live answering questions. We're going to try our best to get to those. If for whatever reason we don't, you can also email us at info@cheryldavid.com. And we are also providing everyone an opportunity to meet with one of the attorneys at our office. Just by the way, your microphone and camera are not on, so chat's going to be the easiest way for us to hear from you, and we do love to hear from you, even if it's just to say hello. And we can't see you, so get comfortable, grab a cookie, grab some coffee. We aren't able to obviously provide those online, but if you come to the office afterwards for an appointment, we will try our best to make that up to you in person. So please commit to staying through the entire webinar. At the end of approximately this hour session, you should leave with a solid understanding of estate planning issues that you and your family face. So including how to pay for long-term care costs, how to qualify for Medicaid benefits, for the nursing home benefits, and the benefits of planning with a family wealth trust or a wealth preservation trust. I've mentioned that everyone who comes to this webinar is entitled to a free personal consultation with one of our attorneys. That is for anyone watching this webinar. We can get into a little more fine-tuned details of your personal situation, the intricacies that affect your family. Those appointments do need to be scheduled in the next 2 weeks and can be done either on the phone or in person. We have several attorneys here at the firm, so anyone who does schedule an appointment, you will be scheduled with one of us. If there is a specific attorney that you need or a specific issue, you may certainly make a note of that when you schedule. So let's jump right in. These are some perilous times in America, and no group is impacted more than seniors, retirees, and after you're gone, your children, your grandchildren, your beneficiaries, even your pets. What happens when you get older and need some assistance? Expenses for nursing home care rise every year, and here in North Carolina, the average annual cost for a nursing home room is more than $300 a day. That is more than $10,000 a month. A hotel room would probably be cheaper than a nursing home and maybe a better experience. But we don't always get to choose, right? Research shows that several million lawsuits are filed in state courts each year alone, and over 400,000 people petition for bankruptcy. And let's not forget about the breakup of marriages. Our divorce rate is one of the highest in the world, and a huge number of Americans have been divorced and remarried several times. Now, when we're handling nursing home protection cases, I get a lot of clients that come to me and ask, do I need to get divorced? And my goal for most of our clients, unless you really truly want a divorce, is to keep marriages intact. The nursing home should not be a barrier to your care. As you can imagine, costs for medical care are out of control, and millions, again, are going to go bankrupt due to crushing medical expenses. In fact, more than 100 million Americans provide full-time care to those with limitations in their daily activities. And recently, we have seen many lawsuits over cheap wills, poorly drafted trusts, powers of attorney. We see a surge of free online documents from do-it-yourself sites like LegalZoom, and many customers don't understand that their documents may not cut it when it comes time to protecting assets. So over the years, our clients have told us they have 6 major concerns. 1, they don't want the government interfering in their hard-earned wealth. They want to make sure that their wealth gets passed on without the governments or courts or nursing homes being involved. They want to make sure that they're not paying any unnecessary taxes or fees. And the big one that we're going to focus on today, avoid nursing home costs. They want their dignity in their final years and to avoid going broke paying for nursing home costs or other crushing medical expenses. We have a lot of clients that tell us they want to protect their family from creditors, from predators. They don't want in-family fighting. And they want a way to pass on their wisdom, their values, and their life lessons. But is knowing enough? Do you know anyone who has ever wanted to lose a few pounds? And tell me, what does it take? I know I do. And that's right, diet and exercise. And how many pounds have we lost knowing that? Not a single pound, right? We all know we need to eat healthy food and exercise to lose more weight. But real progress is only made when you get into action. You make a decision and get into action, and you stick with your decision, telling others out loud that you're committed to your decision. So therefore, I'd like to congratulate you for participating in this session and taking the first step. So let's revisit the reasons that people may not take action. And we found the 2 main reasons that people don't plan. Number 1, procrastination. You know that procrastination means putting off until tomorrow important tasks you should do today. The trouble is, tomorrow never arrives. It's always in the future. So that's why I congratulate you. You're taking action today to see that this important responsibility in your life is looked after. And that leads us to the second reason many people haven't started planning or updated their plan if they have one, and that's lack of knowledge. It's not for lack of trying though. Like you, we find most people we meet have made some attempt to learn or find out information about their options, but are often left confused by what they've read or been told. And in regular law changes on top of it, it's no wonder that people are confused. Unless you are an experienced elder law or estate planning attorney, there's no way that you could keep up on all these changes. There were changes just this year even. So our goals today are to help you understand what proper planning looks like and make sure that you're aware of all the benefits you and your family can achieve with a solid estate plan. So a mistake that many families make is failing to protect their assets from the ravages of long-term care costs. Expenses from nursing home, assisted living facilities, and catastrophic medical bills can rob the elderly of their dignity in their final years. And as we live longer, these expenses They can destroy an estate, leaving nothing to pass on to your heirs. And most people are confused about what long-term care costs are and who pays for them, and they're horrified when they learn the facts. So here is some updated information from Genworth for 2024. That's the most recent one. And even with these numbers in front of you, most people cannot grasp how extraordinarily expensive long-term care is. Clients often tell us they have money set aside, that they can handle these expenses. That is until we let them know just how much money they'll need in a typical case. So as you can see here, private room in a nursing home facility is going to cost you $10,646 a month. So here are the same median costs which are projected about 10 years from now. And as you can see, these numbers are only going up. And a private room in a nursing home is going to cost over $13,000. And most of us don't think this will happen to us, but consider your own friends and family experience and how often it is not a choice, but a necessity to go into a nursing home or into rehab if you need special care. Someone turning 65 today has almost a 70% chance of needing some type of long-term care services and supports in their remaining years. So let's lay it out for you. There are only 5 different ways to pay for these huge long-term care expenses. Obviously, option 1, you can use your own money. That means going through most of your cash and then selling many of your assets to pay these huge bills. People that use option 1 really don't need us. We've had people blow through every last cent and then come to our firm asking for help, and you really don't need us at that point. Where we can make the most impact is coming in either before someone is sick or right at the beginning, while there is still something to lose. And at that point, we often find there's the most to protect. If you qualify, you can purchase long-term care insurance and pay the premiums every month. These costs can be high and you don't need the coverage. And if you don't need the coverage, all the premiums are lost. Now there are certain plans where you might be able to get some back, or a beneficiary might be able to recoup at death. So this is definitely something to look into with your financial advisor if you're interested. If you don't have an advisor, we do share a building with some wonderful advisors. Remember, regular health insurance will not pay for these long-term care costs custodially. So let's look into Medicare, and this is where I get just a ton of confused clients. A lot of people getting tripped up. So they believe Medicare pays for long-term care, but in truth, Medicare pays for a very small amount and only for a limited time, up to usually 100 days. But oftentimes I see people get shut out after 21 days. I get a lot of frantic calls on that day 20, day 21, where people are often feeling like they have to take their loved one out of a nursing home. But there are so many options, and we're going to talk about those today. And this main option is Medicaid. So if you qualify, the federal and state government Medicaid program can step up and pay some of these expenses. In fact, Medicaid pays for about 50% of the nursing home costs for Americans. It's a means-tested program and is available when assets and income comply with the complex medical or Medicaid rules. There are also special VA benefits available to veterans who apply and are approved. We always like to make sure that our clients are aware of this, even though we don't do this VA qualification. We like for our clients to know that this exists, and some of you veterans are already eligible. Now there's a limit on the amount of assets, but often that's a much higher limit than Medicaid. And you can offset that by medical bills and still qualify for VA benefits with even over $100,000. So after new VA regulations went into effect on October 18th, 2018, you cannot qualify if you have assets above $159,240. That was in December of 2024 through November 30th, 2025. Certain assets, such as the value of your home, are not included in that amount. So prior to those VA regulations going into effect, you could just give away any excess and you'd be immediately eligible. But now if we do that, you are penalized for 3 years. So for 3 years, you will not receive VA benefits, up to 5. So for example, let's say you own a home and $200,000 in other assets and give away the excess amount above the net worth limit within 3 years of applying for benefits, you would not receive those benefits. The penalty, would be determined by dividing the amount given away by the maximum benefit for an unmarried veteran for the year it issued to determine the number of months of disqualification. So if you planned ahead and gave away assets more than 3 years in advance, you'd face no consequences, no penalty. So again, we don't handle this, but it is something that many of our clients are eligible for. It does require that you served at least 90 days in one of the major branches, and at least one of those days had to be during wartime, even if you were not boots on the ground. So there you have it. Those are the 5 ways to pay for huge long-term care expenses: using your own money, buying long-term care insurance and hope that your coverage is enough, see if Medicare will cover some of it, become eligible for Medicaid, and finally aid in attendance through the VA. So I'd like to look at a real life family example. I want to introduce you to the Jones family. Bill and Mary have been married for 25 years. Bill is an architect, Mary's a speech therapist. They have 2 kids, Susan and John. Both are married with kids. Susan's an accountant. She calls, she visits, she's the perfect daughter. John, he might live in the basement. Mary has been forgetting some things lately and has trouble with her balance, and she's had several falls, and doctors ultimately diagnosed her with Alzheimer's. So what are Bill's options here? Mary is ineligible for long-term care insurance because she has Alzheimer's. Medicare doesn't apply because there was no hospital stay. So that leaves private pay. So let's look at Bill and Mary's finances. They have $300,000 in savings. Mary spends 5 years in a long-term care facility with an annual fee of $109,032 a year, totaling over $545,000 over that 5-year stay. Of course, Bill became destitute long before that. After Bill and Mary's assets were diminished, Medicaid then picked up to pay for Mary's future long-term care expenses. And of course, Bill and Mary's poor planning decisions meant there was nothing left to pass on to their kids. The long-term care facility was in fact the beneficiary of Bill and Mary's lifetime of work. I think you'll agree we're dealing with a major risk that can literally destroy an estate and your loved ones' lives. In fact, this area of planning has been the most important issue for a lot of our clients. They have witnessed their friends and their family lose everything because of these catastrophic long-term care costs. Had their loved ones been diagnosed with cancer, insurance likely would have covered it. But they were dealt a bad hand when someone was diagnosed with Alzheimer's or had a stroke, and insurance is not covering like I think they should personally. So you might be wondering if there's anything that can be done to save some of your hard-earned assets. That's probably why you're here today, while at the same time getting appropriate care. And yes, there is, but only if you start planning before you need long-term care or contact us before you've run out of money. And based on the Medicaid rules, there are legal steps you can take to preserve your estate and be ready to qualify for Medicaid if the need arises. But I must stress, it will be difficult, impossible to help you if you wait. So that's exactly why you need to plan now. Regardless of whatever concerns you may have going on, if you need to go into a nursing home, you can qualify for Medicaid and avoid losing your nest egg to long-term care costs. And your loved ones will still receive the inheritance that you intended to pass on. Or maybe you have a spouse at home that you don't want to leave destitute. We can make sure that this nest egg is here for them. And I think it's important to understand the healthcare roulette wheel we have in America. And I mentioned this a minute ago, but if you happen to get certain illnesses, the government through Medicare doesn't hesitate to step right in and pay almost all your medical bills. Illnesses like cancer, heart disease, arthritis, diabetes. But if you're unlucky and the wheel stops on Alzheimer's, dementia, Parkinson's, or a stroke, you not only have to suffer that illness, but chances are you will blow through every last penny. So for those of you concerned the government should not be paying for these long-term care concerns, maybe you should demand that they not pay for any of the other random diseases they subsidize. Just a thought. Okay, so with all that out of the way, let me explain in basic terms how Medicaid works. So let's say you need long-term care services tomorrow and applied for Medicaid. Now, most of you sitting through this webinar would be denied because you don't qualify. They will only step in and help under certain circumstances. So here are the requirements. You need to be 65 years or older, or if you're younger, blind or disabled. As far as minimum income, in North Carolina, as long as your monthly income is less than the monthly cost of the facility, you'll be okay. Now, there's different requirements for special assistance through assisted living, for in-home care Medicaid. That's not what we're talking about today. We are talking about long-term care Medicaid in a nursing home. And to date, I really have not had income be an issue or an obstacle for our clients because most people don't receive $10,000 of monthly income. And if you do, the government expects that you have enough to pay your way. There's also minimum asset rules. So the sick person in care is limited to $2,000. So if you are single and in a nursing home or widowed in a nursing home, you are only allowed to have $2,000. This is where we can step in. We can protect, maybe not all, but a huge chunk of that overage. Now, if you're married, your spouse is entitled to a community spouse resource allowance. It is a range, but you do not get to keep everything unless you are under, it's around $31,000, $32,000. So obviously your age and whether or not you're blind or disabled are easy to figure out, but what do minimum income and assets mean? I think we've hit on the income, but in the Medicaid application process, all your assets are divided into two piles. The first pile is for countable assets. These are assets that count towards your asset cap or your spouse's asset cap that I mentioned. And the second pile is non-countable assets. These are assets that a person can keep and the value of those assets does not count against the asset cap. So let's look at what assets qualify as countable assets. So we have investments. Maybe this is your checking account, your savings account, your brokerage, your CDs, your stocks, money markets. Any cash in the bank is going to be a countable asset. Again, you being the sick person, allowed to have a maximum of $2,000. Now here's a list of non-countable assets. Your home, but I want to spend some time on this one. Though you can get on Medicaid with a home, as long as that home, I believe the government changed this year to it must be under $1 million. The issue is anyone who gets on Medicaid signs a form for state recovery, basically stating when I pass away, the state of North Carolina, after me and my spouse, or just you if you're a widow or single, gets to recover from that home. They have a lien on that property to pay back up to the amount that Medicaid paid in. Now in North Carolina, as of today, there are some really nice deed options to protect your home. But I cannot tell you how many people I meet a month that did not know this information. And surely the Medicaid caseworkers aren't telling you. They lose a lot of money when you protect your home. But what I want to tell you now is there is a set of deeds that we can use to protect your home. We just either have to have that done before you pass away, or at a minimum, please, please, please create a power of attorney with specific Medicaid asset preservation triggers that allow us to protect your home later. So again, if you're not going to protect your home today, which a lot of our clients don't, and I understand, I must make sure you have a special power of attorney that lets me protect it later. And again, the state of North Carolina loses a lot of money when you save your home. So the statutory power of attorney that you can get for free, the power of attorney that you can get from wills and trusts or from LegalZoom is not going to cut it. And these clients will lose their home. So if for nothing else, I hope you learned today, we can protect your home. But even though Medicaid's not going to take your house when you go into the facility, they will attempt to recover when you pass away. Household goods are non-countable. There's a burial exclusion and burial space items. They will allow you to keep one automobile. Now we have some tricks on, not tricks, but tips on things that we can do to protect that vehicle when you pass away. Personal items and non-marketable items are also non-countable. So one strategy that may seem obvious is to move as many assets as you can from the countable pile to the non-countable pile. And if you can get to the minimum countable assets this way, you're done. You've got a good shot at qualifying for Medicaid. And although that might sound simple, it is not, as you can imagine, that easy. So trying to get your countable assets reduced enough by changing them to non-countable assets is an almost impossible task for many people. Another strategy we've seen people try is to transfer all their assets to their kids or their close friends and then apply for Medicaid. Despite the obvious dangers of transferring everything you own to others, Medicaid will deny your application and you will be assessed a penalty. So I cannot tell you how many times a year I have heard a client saying, I will sell my house to my child for $1. Don't bother. Medicaid is going to say that everything above that dollar was a gift and there will be a penalty. In North Carolina, it's going to be quite a big one. Medicaid looks back 60 months or 5 years, if you've heard of this 5-year look back, from the date you apply for benefits. And if you've given away assets for less than fair market value, like giving a car to a grandchild or selling a house for $1, you would cause yourself or your family a penalty period. So the penalty period is the amount of gifted assets divided by the monthly average private pay rate for a nursing home. And this is called the 5-year look back. So if you don't believe you'll need benefits for 5 years, go ahead and transfer assets, although I really don't recommend that, and wait 60 months. Now we have to find a way to look after those financially inexperienced kids so they can't spend or risk all your money. So let's say Bill and Mary transfer everything to their 2 kids, expecting that the kids are going to keep the assets safe for us and only use them when mom and dad need. What's wrong with that? So let's assume the best, that Susan and John are as honest as can be and don't dip into mom and dad's assets. But what if either of these kids gets divorced, has a car accident and seriously injures someone, has a legal judgment against them, creditors, a bankruptcy? All of mom and dad's assets are at risk. So many people assume their living revocable trust will do the job, but they are sadly mistaken. Revocable trusts protect estates in many ways. They are amazing for avoiding probate, but they are not designed to shield assets from Medicaid. And it's a sad fact that all assets in a revocable trust are up for grabs for Medicaid purposes, almost as if those assets weren't in a trust at all. So to reiterate, because I know we have some clients on here that have a revocable trust, there's a lot of benefits. They're going to avoid probate. They're going to minimize taxes that you may have otherwise had. They can provide divorce and creditor protection for our beneficiaries, free marriage protection, protect our retirement accounts. They can do a lot, but they cannot protect against the nursing home. So if you are one of our trust clients with a revocable trust, it's going to perform well in most areas is what I'm getting at, but it doesn't help when you apply for Medicaid benefits. The watchful eyes of Medicaid bureaucrats spot the assets in your trust. They immediately jump in to prevent qualification for government benefits and demand that assets in the trust be used to pay for those expenses. So that's not a good result. and all this great planning can really go down the drain. But don't worry, there is a better bucket that we can use to qualify for Medicaid benefits. We do have a different type of trust called a Medicaid Asset Protection Trust. Now, like the revocable trust that you may have heard of, again, a trust that is meant to keep your family out of court, a revocable trust, you have the right to retain income if you want. Sometimes we don't want to do that because if we get sick, we'll lose that income to the nursing home. But you would name someone else to act as your trustee. So typically with an irrevocable trust, you do not want to be your own trustee. Normally you would name siblings or children or friends as your trustee. Now, unlike the revocable trust, the new Medicaid Protection Trust is irrevocable, and once in place, it cannot be changed. In addition, although you have the right to income from the trust, you cannot reach in and spend the principal. Now, with these safeguards in place, Medicaid does not count these assets when determining whether you qualify for Medicaid benefits. After the 60-month look-back period, all assets in that trust are protected. Okay, so let's look at Edith and Ed's Medicaid application. This is a couple that has a total of $700,000, a home of $500,000, home furnishings of $100,000, a Mercedes that's worth $70,000, savings of $20,000, and a prepaid benefit, funeral benefit of $10,000. They have total monthly income of $7,000. Husband has $5,000, wife has $2,000. Edith has long-term care issues, and they have applied for Medicaid benefits. So, question, will they be approved? And because I haven't given you a lot of information, let me tell you a little bit. They did a trust 60 months ago, and they placed their assets inside of this trust. And now, when we need care 5 years later, they will be approved. Even with $700,000. So yes, Edith is approved, believe it or not. Even with $700,000 and all this income, we can get her on Medicaid. Now, we do not risk any of her husband's money going to the facility. The healthy spouse does get to retain their benefits. And the $700,000, by placing that in a trust 5 years in advance, have protected those assets. Okay, how about another typical case? So here we have Ralph and Ruth. In this case, Ruth applies for Medicaid assistance. So here is a description of their financial circumstances. They have total assets of $100,000, a mobile home worth $35,000, home furnishings of $1,000, a car that's $4,000, $5,000 of savings, and a retirement account of $55,000. Now, monthly income, I'm not really worried about it. As I mentioned earlier, as long as the sick person's income is less than the monthly cost of the facility, and $2,200 a month is certainly less than that facility is going to cost, we don't have income restrictions. Now, because this comes up all the time, Ralph's income is protected. They, in North Carolina, are not going to take the healthy spouse's income. In fact, there's a little calculation, I won't get into it too much, but sometimes we are even in a position where some of Ruth's income can be transferred to Ralph to make sure he is whole, that he has enough to pay his bills. So income, not a concern. Assets are a big concern here. So I will let you know, they can't simply give it away. They didn't do an irrevocable trust 60 months in advance, so they're not going to be eligible. And giving it away now is just not an option. I mentioned that there is a penalty for giving assets away. So as much as they'd love to give it to their kids, for every $10,317 that's gifted away, there will be a 1-month penalty at the nursing home. So we do have clients sometimes that will gift away $10,000. They're at a facility that's $12,000 a month. We have just put ourselves in quite a pickle. Giving away 10 just cost us 12. So there's a much better way in the state of North Carolina than giving assets to your kids, okay? Now, there is a minimum and maximum amount of money that Medicaid will let a community spouse keep. This is the Community Spouse Resource Allowance. It has a $31,584 minimum. So let's say they only had $20,000 of assets or $30,000 of assets. They would actually let Ralph keep all of it. But they only let you keep up to $157,920. And this does not mean that if they have $150,000 or $157,000 that they're going to let Ralph keep all of it. In fact, let's say he only had $100,000 of assets. They only attribute half of that to him. So he would actually get to keep 50% and the rest would go away. Now we have some of these clients that come in and they have well over the resource allowance. Let's say we have a client with $400,000, and I've told you in some circumstances they let you keep half. Well, with a $400,000 estate, half would be $200,000. That is above the maximum that Medicaid lets us keep. So in this instance, someone with $400,000 estate between him and their spouse is only going to get to keep the maximum of $157,920. Now, I don't want you to be worried that if you haven't done all this planning in advance, we're out of luck. North Carolina actually has a loophole that lets us protect assets provided you have a healthy spouse still living at home. And in these instances, as long as we have the right documents, like the power of attorney that allows us to sign off on behalf of your spouse or yourself, as long as there's a spouse at home, we can often protect almost everything. Now, we might have to convert it into an income stream using a special Medicaid compliant annuity, but it is something that lets us protect your nest egg. So I don't want you to be worried if you haven't done these plans in 5 years notice or 5 years notice. There are still ways for us to protect assets. Now, let's say you don't have a spouse at home. We can still, even without an irrevocable trust, protect up to half of your assets plus a piece of real estate. Probably over half if you have a piece of real estate. So the important thing is just make sure you contact us before you've spent everything. I'm not going to spend too much time going into how we do that or how much we can protect, but for a single person, we can protect your house plus about half. And for a married couple, we can almost usually protect everything as long as it is an account that can be liquidated. But as I mentioned, they didn't do any of that. They never contacted us. They didn't contact us when she went into the facility, and they did not do any planning 60 months in advance, so they will be denied if they were to apply right away. Frustrating, right? In most instances, the local Medicaid office is forbidden to give any kind of advice to applicants. They're not going to tell you to come see me or an elder law attorney. That's why if this protection is important to you, having a knowledgeable elder law attorney guiding you is absolutely a must. Now, I mentioned this Medicaid Protection Trust. There are many variations. We can decide if you want this kind of planning to protect your estate from long-term care expenses. We can show you the strategies that best suit your needs and demonstrate how much of your estate is at risk and how much can be saved. And for those of you that don't have 5 years notice, I find the majority of our clients don't, do not fret. We can still often protect something, even if it's not everything, usually up to half, as long as we have the right protections in place in advance. And this would be that power of attorney that I keep talking about. And again, not all powers of attorney are created equal. A lot of clients that come in that just had a basic power of attorney drafted up from maybe a church or from LegalZoom or the free one that you get online, it's not good enough. And these are clients that we often lose the most with. So let's look at how this planning could have worked out for Bill and Mary if they had planned in advance. So remember, Mary needed to be placed in a long-term care facility. She was there for 5 years, eating up over $545,000 and bankrupting them. If Bill and Mary had met with a qualified estate planning attorney 5 years before their long-term care needs, a Medicaid protection trust could have been created and the 5-year clock would have started ticking. When Mary needed services, the income from the trust could have been used for her care. The principal would have been preserved for the kids. At least $300,000 would have been saved, and they could have left an inheritance for their kids. And after hearing about these benefits, many of our clients shake their head and ask, why doesn't everyone do this? And I can confidently say that most do once they understand the scope of the risk and what's needed, but a plan is required to be put in place in advance. And for those clients that did not plan 5 years in advance, there are still options. Bill and Mary do not need to lose everything as long as they can consult with an elder law attorney. So we believe at some point each family must ask, how will I be remembered? Will your spouse or children throw up their hands and just wonder how things could have been left such a mess? We see clients every day who are trying to sort out poor planning choices for their family. Like all things in life, you have a choice. Okay, you can leave behind the wreckage of turmoil and trouble by failing to plan sensibly, or you can leave a different kind of legacy. So what we're saying is you can create a plan that actually works, and more importantly, create a reputation as a good steward of the gifts bestowed on you and your family. We know this is important to you, otherwise you would not have taken time to be here. So because protection from nursing homes require different planning, we have to carefully analyze your estate and determine what kind of trust or what kind of plan makes the most sense for you. For some of you, it might be creating this Medicaid trust. For some of you, it might be, let's just go ahead and protect your house so we don't have to worry about this later, so you don't have to lose a night of sleep wondering what's going to happen to my home. For some of you, maybe we just need to get this power of attorney in place so that we can kick this ball down the road and just come back to it and have the tools in place now for the future. But whatever makes sense, I highly recommend having a consult with one of us attorneys here at the Law Offices of Cheryl David so we can analyze your situation and figure out what makes the most sense to you. So if you have questions of anything you've heard, please write those down. We can certainly talk about that on our follow-up. So I think we can all agree that a good estate plan is one that is tailored to your family's personal needs, as opposed to canned text pulled out of a word processor someplace with your names inserted into the appropriate places. We call those cookie cutter documents. And I don't know about you, but we believe the cookie cutter needs to stay in the kitchen, okay? With the proper estate planning and proper guidance, we can be the difference between losing everything or keeping half or keeping everything. That's huge. But we need to make sure that you have documents in place that are really serving their purpose. We don't want you to be fooled thinking there's a financial shortcut to getting the kind of plan you deserve. As you can see from the examples we've shared, it takes extraordinary expertise, time, and persistence to get your plan designed, drafted, executed, and funded properly. There are no shortcuts, and that's a shame. It's a shame that estate planning documents can't be tested before you need them. Almost every other product allows you to test drive it, handle it, or put it through its paces, but you won't know if your estate plan documents worked until you actually need them. And of course, by then it's oftentimes too late to make changes. We worry about all those people there who out there who think that things are looked after when in truth they're handing their family nothing but trouble to deal with when they die. All right, so let's review your options. We know won't work. You can buy a one-size-fits-all living trust for $50 down at the stationery store. You could spend $300 for one of those word processor documents cranked out by many attorneys. We've pretty much established that downloadable do-yourself wills and trusts are a pretty bad idea. But it's also important to be clear that you simply can't ask a law firm how much they charge for a trust when you can't be sure if all of the provisions that are most important to your family are actually addressed. Estate planning is not an area to shop for bargains because, as we know, you get what you pay for. In our firm, the documents aren't what you're paying for. You are paying for individual counsel and design of your plan to meet specific needs of your family and planning goals. Whether you end up creating or updating your plan with us or someone else, you need to look for these things in a firm. Work with a law firm who takes their time and listens to you. Work with an attorney that feels right to you. It's often hard to gauge whether a new person you meet is in the business for the right reason. Sometimes you just have to trust your gut. Make sure you work with professionals who do not charge by the hour. You need the ability to call your lawyer without fear that you're going to get a second mortgage on your home in order to afford the conversation. We want to talk with you about your questions. Sometimes our clients don't need a huge complex plan like this. Sometimes you just need a deed. Sometimes you just need a power of attorney. Sometimes you just need a little extra help. No matter your situation, when we speak with you about your questions, you can count on us telling you precisely how much a service will cost and how long the work will take before. So for those of you interested in Medicaid pre-planning, the nursing home and other long-term care protections require substantially more planning. We have to create a completely separate set of documents, sometimes in addition to a revocable trust that you may have. This trust is very strict, the Medicaid Protection Trust. It has strict rules that allow you to keep assets in the family, but still qualify for Medicaid. Because there are so many variables, we'll meet with you to determine what assets will need to be protected and the level of work that will be required. And once we have that entire picture, we'll share what the flat fee will be, so there won't be any surprises. You'll know exactly how much of your estate can be protected. It's hard for me to quote these fees online because it really depends on what we need to protect. I can tell you generally our asset protection trusts or our Medicaid protection trusts are going to be anywhere from $7,500 to $12,000, depending on what we need to protect. There are also deeds that we can do to protect your house. Typically, those are going to run around $3,500 a property. Now, the really neat thing with these deeds, or I can protect your home without a 5-year penalty, without a 5-year look back getting in our way. We are often hired by clients where someone's already in the nursing home. They hire us for these deeds, and we can protect the house immediately. And we do not have to worry about estate recovery when our client passes away. The home can go to the family. Now, as far as what does it cost to get someone on Medicaid when someone's already in the nursing home and we have hundreds of thousands of dollars to protect, that's really a case-by-case basis, but typically upwards of $12,000. Right, so the information portion of this program is over. Now, I know there's no way that you can make a decision today about exactly what services you need. You may not know, but you can give us an idea of what level of protection you would like to investigate further. You can point out what issues interested you and those you saw no need for. This one is also going to be private. It'll help me get to know you and see how we can help. Now, this meeting will be with one of our attorneys here. It may be with me, it may be with one of our other attorneys well-versed in asset protection. So many of you are wondering how you can get more information about the issues we discussed today and the impacts on your family without committing yourself to move forward. I skipped ahead. But basically, please schedule a free personal consultation with one of our attorneys so that we can discuss what the next step is. You can book that online. We have a link that we've been posting. You may have gotten that emailed. We also tend to call people the day after they've watched this within a couple days after watching this. So you may get a call from us tomorrow to help schedule your appointment. And space is limited, so we do require that these appointments be within the next couple weeks. Otherwise, you're welcome to come anytime, but there will be a $425 consult fee. We offer this consult fee waived over the next 2 weeks while this information is fresh. We find that we don't often have to spend as much time teaching when someone has just come from a webinar. So I'm going to get to it because I know I have gone over the limit that I was hoping we would have. I will leave you with one final thought. Pablo Picasso, who is generally known as a genius in artistic matters, admonished others not to procrastinate. He said, only put off until tomorrow what you are willing to die having left undone. We're ready to help you take care of this, so don't leave things undone. Thank you so much for giving me your time. I know it's valuable, and I look forward to seeing you in the future.